And the Building Bridges Initiative legal team heads to the Court of Appeal on Monday to contest last evening's shocker from the High Court that declared unconstitutional and null the push for a referendum spearheaded by President Uhuru Kenyatta and ODM leader Raila Odinga. Paul Mwangi and Professor Ben Sihanya, who are part of the BBI legal team, accused the 5-judge High Court bench that tore into the Constitution Amendment Bill 2020 of judicial adventurism. They want the Court of Appeal to overturn yesterday's judgment. And as Francis Kashiri reports, the imminent legal tussle in the Court of Appeal further delays the clamor for constitutional changes before next year's general election.
After the BBI Thursday night of shock, proponents of constitutional amendments through a popular initiative are preparing to salvage the process that was declared unconstitutional by a 5 High Court judge bench.
For sure, the appeals are going to happen, and somebody has to relook at this, and somebody has to see through what is purely a political exercise. And we shall prove to the public and to the higher courts that this was sheer politics. This is not law.
A permanent injunction be and is hereby issued restraining the IEBC from undertaking any processes required under Article 257.4 and 257.5 in respect of the Constitution of Kenya Amendment Bill 2020.
In a nutshell, it means BBI, as we know it, is dead. They cannot revive it unless that judgment is overturned by a higher court, which is the Court of Appeal and the Supreme Court, which I do not see it happening before we even go to a general election.
So stopping reggae, as it were, would not be a very productive way. Stopping the process, as it were, would not be a very productive way of solving the problem. So what? Where do we go from here? Do we start completely afresh to address the 9 agenda items?
The BBI team from the onset raising issues on the doctrine of basic structure on articles in the Constitution that are unamendable.
Once you purport to alter the basic structure, do we still have the same constitution? So the court said in a nutshell that if you want to alter the basic structure, you have to follow the processes akin to those of enacting a new constitution.
Okay. What that means is that if you ever want to amend the Constitution of Kenya, you will always have to go to the judiciary and ask them whether what you want to deal with is amendable or not. It's a basic structure. It's a decision judges will have to make every time anybody wants to amend the Constitution. So who owns this Constitution now? This Constitution is now owned by judges. They are now above people's sovereignty.
They will also be contesting the judge's verdict that IEBC as currently constituted did not have the requisite quorum to verify signatures supporting a popular initiative or conducting a referendum.
When the Constitution says that a commission may have at least 3 commissioners, but then the Act talks about a quorum of 5, and then the regulations at the statute say that which one should supersede. That is Constitutional Law 101 under Article 2, that the Constitution is supreme. So if the Constitution says that 3 are sufficient, 3 are sufficient. So many by-elections have been conducted by the 3 commissioners at IEBC. Are we saying that those are null and void ab initio from the beginning? So those are some of the troubling issues that are easily appealable.
The court said that the collection of signatures was wrong because people were not given copies. Evidence was before the court. Everybody who signed, the 4 million of them, have signed and said, I have read and understood the bill. Everybody, 4 million people. The court still somehow got to the determination that the people were not given the bills. And yet they have signed that they were given. So I do not see how such things can stand in a higher court.
President Uhuru Kenyatta was also indicted by the 5 High Court judges for initiating and spearheading the Constitution Amendment push.
In our view, to permit the President to initiate such amendments through a popular initiative and then sprint to the finishing line to await and receive it and to determine its ultimate fate would have the effect of granting to him both the roles of the promoter and the referee.
Let's read Articles 255, 256, 257, it doesn't say who, it doesn't identify specifically who can and who cannot propose amendment that should be done through a referendum.
Because there is no evidence, there is nothing that suggests that the president is the one who was amending the constitution. The evidence was before the court that the constitution was being amended by what called itself a voluntary political alliance of people, which is led and coordinated by Junet Mohammed and Dennis Wawero. They went to court and they said so, and the court totally ignored that.
There are 13 judges in the Court of Appeal after some retired and others promoted to the Supreme Court, while Kihara Kariuki was appointed Attorney General. Francis Gashuri, Citizen TV.